Mr. President.
Senator from Maryland.
Thank you, Mr. President. I rise to recognize the 36th Annual Women's History Month. This year in Maryland, we have some special advancements to celebrate. In Maryland, voters chose Brooke Lehrman as the first ever woman independently elected to a statewide office as our new controller. Marylanders also elected Aruna Miller as our second female lieutenant governor and first woman of color and immigrant elected to statewide office in Maryland. Here in the United States Congress, we have the highest percentage of women serving in history, 28% across both the House of Representatives and here in the Senate. They build on the legacy of pioneers like former Maryland Senator Barbara Mikulski. She was the first Democratic woman to win a seat in both the House and the Senate, until recently held the record as the longest-serving female senator, having now been surpassed by Senator Feinstein of California. As the late Supreme Court Justice Ruth Bader Ginsburg said, "Women belong in all places where decisions are being made." I was proud to testify recently at the Senate Judiciary Committee's hearing regarding the Equal Rights Amendment, the ERA. At the most basic level, the ERA is a continuation of centuries-long process of expanding what is meant by we the people. The main clause of the amendment simply states, "Equality of rights under the law shall not be abridged by the United States or by any state on account of sex." The vast majority of Americans will hear this and think, of course, this should be part of our Constitution. In fact, many Americans believe that it's already part of our Constitution. It has been overwhelmingly supported by the American public, regardless of political affiliation. A poll conducted by the Pew Research Center in the spring of 2020 found that 78% support the Equal Rights Amendment being added to the Constitution. A separate poll from the AP North similarly found 3/4 of Americans in support of the ERA, with large majorities of both Democrats and Republicans in favor of the Equal Rights Amendment. In addition, 22 states, including my home state of Maryland, have established state-level ERAs. 6 more have some form of explicit prohibition against sex discrimination in their constitution. Other states are actively in the process of adding the ERA. For example, in January, the New York State Legislature sent a state-level ERA to the voters for consideration on their 2024 ballot. So we already have it in the majority of the constitutions among the states. It's time that it be added to the United States Constitution. Indeed, 85% of countries have explicit prohibitions against governmental discrimination on the basis of sex. The United States is the only industrial democracy that does not include an explicit prohibition in their provision in their Constitution. We want the United States to continue to be the gold standard when it comes to women's equality, opportunity, and protection against discrimination. Our inaction on this issue is an outdated barrier to our credibility on the global stage. When Congress passed the Equal Rights Amendment and sent it to the states for ratification, it included a 7-year time limit for the states to ratify in the preamble of the resolution proposing the Equal Rights Amendments to the states. This deadline was later extended for 3 years until 1982, but a total of 35 of the 38 states ratified the amendment by the extended date of 1982. Mr. President, there's nothing in the Constitution that provides for a time limit on a ratification of a constitutional amendment. In 2017, Nevada activists led by State Senator Pat Spearman reunited the push for the ERA through the first state ratification since 1977. Illinois followed in 2019. Virginia became the 38th and final state required by the Constitution to ratify the ERA in 2020. Since then, the only major remaining barrier has been the ambiguity caused by the fact that the 3 final ratifications occurred after the time set in the original resolution passed by Congress. With Senator Lisa Murkowski of Alaska, I introduced a joint resolution to resolve that ambiguity, to remove that last barrier. 38 states have ratified. It should be part of our Constitution. I would remove the arbitrary deadline the Congress once set and to recognize the ERA as validly ratified by the required 38 states. Our Senate Joint Resolution 4 is co-sponsored by 52 United States senators, including Senator Collins and all Senate Democrats and independents. This action is well within the Congress' broad power over the amendment process laid out in Article 5 of our Constitution. As the ERA Coalition put it, this is the first time in our history that an amendment has fulfilled all ratification requirements under Article 5 and has not been recognized. There is precedent both for constitutional amendments to be ratified after significant periods and for Congress to pass resolutions to recognize amendments as validly ratified. There is simply no constitutional reason nor court ruling that bars us from taking this step. I point out to my colleagues that the 27th Amendment to the Constitution, which deals with congressional pay increases, was ratified, took over 200 years to ratify it, and it's now part of the Constitution of the United States. There are many reasons why it's important that we do act. The reality is that women still face serious challenges on account of sex, and that our existing legal framework does not always provide a sufficient remedy. As the 28th Amendment, the ERA would serve as a new tool for Congress, for federal agencies, and in the courts to advance equality in the fields of workforce and pay, pregnancy discrimination, sexual harassment and violence, reproductive autonomy, and protection of the LGBTQ+ individuals. The ERA would serve as a constitutional backstop for existing and new legislation. It would also signal to the courts that they should apply a more rigorous level of review to laws and governmental policies that discriminate on the basis of sex. Enshrining this protection in the Constitution also ensures enduring protection for all Americans across the country. Through this action, we can finish the work started by the generations before us in order to secure the future of the generations to come. Our strength is in our values, and no value is more American than equality. There should be no time limit on equality. Mr. President, I suggest the absence of quorum.
The clerk will call